I think they're probably I think in general, like on habits, United States.
Yes. Okay.
Big animal, it's just that I'm always in the window. Yeah, sure. Yeah. Players. Still, I mean, you guys are really, yeah. Last night. But, I apologize.
All right, everyone, I am going to call the docket, so everyone please have a seat. Today is Monday. It's a day of new beginnings. But before we call the docket, could somebody have Caroline come out? All right, and this is the first time we have 3 female deputies in the courtroom. So you know what that means. Don't try them. Because for us to have female deputies, you know, they passed everything and they are better than the best. All right. And today is, I think it's today. Diana, is today your birthday? All right, today is her actual birthday, and Caroline's birthday is later in the week. So we're going to do our best for them to have a great day, because nobody ever intends to work on their birthday, but they are. So we're going to make sure they have a great day today. All right, when I call your name, please let me know you are here. George Ibarra. George Ibarra. Well, that's not starting off great. Lutrell Miles is in custody. Joe Vincent Batala, custody. Mark Anthony Rodriguez, Yvonne Monica Perez, custody. Daniel Perez. Sean McHaslett, Cruz Rivas. Aran Bawani, custody. Celine Briard. And custody is Anthony Cantu, Shawana Canales, Manuel Mendoza. Thank you. Michael Ball. Terrence Truesdale. Larry Berry. Marco Calendres. Angel Guevas. Am I pronouncing that last name correctly?
Yes.
All right. Angel Guevas. Mario Aguilar is in custody. Eros Rodriguez. Kevin Jones, custody. Clinton Barnes. Lupe Martinez. Thank you. Hi, thanks for coming. Christopher Morrison. Edgar Aguilar is in jail. Nancy Zavala. Christian Smith,
Here.
Anthony Woodard.
Here, Your Honor.
It's this that's going in and out.
This thing?
And that on the back. Chardonnay Lockhart is in custody. Patrick Sanchez, custody. Wilbert Villamil, custody. Marco Marino Vasquez, Orlando Cuevas, Chris Lynn, custody. Jonathan Yost, custody. Christopher Gonzalez, thank you. Pierce Jones.
Treasurer Counsel.
Is there anyone who is present and your name was not called or you came in late? Yes, sir. What's your name? Thomas and the last name? Valderas. Do you know who your attorney is?
He pronounced his name, but he's in his way. I texted his phone.
All right. Do you know your case number or SID number?
Number is 876-600.
All right, just have a seat. We'll get with you. Anyone else? All right, everyone, these are the rules of the court. We do have 3 deputies. However, there's a limited number of inmates that can be in the box. So once you request your client, please do not leave the courtroom. If your client speaks a language other than English or feels more comfortable speaking in a language other than English, ask for the interpreter. Yes, we will need an interpreter here. Do not approach the clerk or the coordinator for resets or for continuances. I'm the only person that can give that to you. On this side are files for criminal trial division. On this side are files for family violence. Just grab a file, place it on either party's desk, have a seat. They will call you up as they receive your files. In this court, it's first come, first served. The only exception is if you call for an interpreter because we have a limited number of interpreters. Over to my right, your left, is the probation officer. Vashon, could you raise your hand? Do not back up into her. Do not turn your back towards her because she is sitting down. And if you turn your back towards her, that's not a good view. Even if you think it is a good view, it's not a good view. So please do not crowd her. Please do not put your paperwork or anything on her desk. That's her desk. Consider that her office. To my left, the court reporter. Today is her birthday. Consider that her office. Do not put your desk or your papers on there because she has her machine and her equipment set up, and that machine costs about $10,000. Now, if you want to move things around over there and perhaps ruin her machine, then just pull out your certified check or something to pay for her $10,000 machine. So everyone, let's be kind to each other. Let's be nice. Let's confer pleasantly. If you have an inmate that you want brought out, let the deputy know. Do not approach the court unless you have conferred with the state and conferred with your client. Everyone, please confer. And someone came in late. Sir, what's your name? Yes, what's your name? Nancy? Last name? Zavala? Do you know who your attorney is? Do you know your case number or SID number?
14495, page 14.
All right, thank you. Can I see the file on Christopher Gonzalez? Oh, sorry. Caroline, on Christopher Gonzalez, can you do a reset for Thursday? That's when his attorney will be able to be here. Could I see Christopher Gonzalez?
Yes, Your Honor.
All right, you have been an appointed attorney. His name is Michael DeLeon.
Yes, ma'am.
He is actually out of county, so he will be able to be here on Thursday. So I'm gonna have you come back on Thursday at 9, okay?
Yes, ma'am.
All right, they'll give you a reset form, then you're excused.
You have a good day.
All right, thank you, you too. Mhm.
No, he's not here.
Just to show you that that was the truth.
Mhm.
But you see that there are and her mental evaluations, you know, a portion of it is going to be done on the 20th. Okay. So when we but you said, oh, well, that you want to do.
No. And you say when it will be done on the 20th?
That portion will be done on the 20th, so we can have a.
Okay, let me look at the calendar.
That's one simple.
You want to grab a pen?
Okay.
Oh, okay. We're gonna- Yeah.
All right, so then if we bring this back on the 27th, would that be enough?
Okay.
All right, so let the deputy know and we'll recall her on the 27th. All right, thank you.
No, not without your attorney. Let's wait till. Oh, wait, great, second chair. Second chair, second motion. Straight ahead, we'll talk to the afternoon.
Oh, yeah. And Caroline,
Oh, yeah.
on Chardonnay Lockhart, it's going to be a phantom date for July 27th, and she's in custody.
Oh, that's.
This probation has just told me they have another portion to complete of her evaluation.
Oh, okay.
Oh, Mr. Colindres, he's not here right now. I'm trying to get him here. Marco Colindres. Is he here? No, he's FDA. I just gonna send him a message to see what time he will. And I will check back in.
I'll let him know. So you're kind of here. He's on his way.
Hello. Yes. Oh, you need to have the file pull. You need to have the file pull. Lupe Martinez, where's your client? Good morning. How's it going?
It's good. Did you have a good weekend?
Yes, I did, although I did go to get my oil changed yesterday, well, Saturday. Yada, 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 like on Seinfeld,
Oh, yeah.
$3,000 problem.
That's an expensive.
Yes.
Oil change.
All right. So have you received all the discovery?
We've received,
All right. Could everyone make sure you please whisper?
all the discovery that's available at this time. We are missing some stuff. That's already expires, they're quite old. We're gonna be looking for that stuff and hopefully we'll be able to get it before long.
So what you need are the judgments. Anything else? Is this a drug law or?
It's a DWI third judge and but the DWIs are from 1973, they're quite old, so. I was just gonna do some investigation and I think defense counsel is gonna do some investigation to see what we want to do. This is a DWI third, want to make sure it's.
So there's no blood draw or anything of that nature?
No, there's no blood draw, it's a press.
Okay. All right, let me look at the calendar. Caroline, can you reset Lupe Martinez for August 14th? Oh, Lupe Martinez is up here, Deputy Laura. I think she wants to make sure your client has his indictment, yes. And that'll be a discovery reset. All right, is there anything else?
No, you're.
All right, once you sign the reset form, you're excused. You're welcome.
Christian Smith. Nancy Solano.
Yes,
Chardonnay Lockhart. My client, I know she gave you an update earlier that
Yes.
we're gonna have to do mental health evaluation. I think my client's been in custody since May. It's
Mhm.
been quite a while since we've sentenced her.
Mhm.
We held her in custody for the TAP evaluation for this. Is there any way she can get out? There's-
let's see if they actually have this done because they're telling me it's going to be done on the 20th. Yes,
is there any way we can get her out?
no, because I don't want her out when we have all these issues and they're close to finishing the process. But I tell you what, they're going to do it on the 20th. I reset it for the 27th, but if it's done on the 20th and they have it sooner, just ask and we'll make sure that she's brought over before then.
I get an email. I get I don't get an email. For the trip that she exists.
All right.
I want to that.
Oh, just check with the deputies and make sure they haven't sent her back, but they may be able to bring her up. Has Chardonnay been sent back?
No, I haven't put it back yet.
Okay. He just wants to speak with her for a moment.
Judge, I think just reapproach and say, let her out, so you can tell her.
Sure, I can tell her what's going on.
Just to do a little show.
Yes, no problem.
Get that.
Oh.
Yeah.
Okay, no confusion. We approach her, you know.
No, hi.
Good morning.
Do you all have a file for me?
We do, we.
Oh, you're behind the,
Anthony,
Oh, I'm sorry.
that's okay.
It's my first time
Huh?
in a while.
yell at him, Judge, yell at him.
All right, you all are on the wrong side too.
Yes.
So are you all here for Anthony Woodard?
Yes.
Where is he?
He's in the back row in the red. and white.
Anthony Woodard? All right, where are we on discovery?
Your Honor, I was just assigned to the case on Friday. It's a first trial setting. I'm gonna go through it very thoroughly in the next few days, see if there's anything missing, but I have essentially barely read the case, so we would ask for a reset. And I don't know if you can set a case into October.
Oh, no.
No, okay.
How about December?
Well, since we're,
Next year?
yes, since we're doing wishes, how about August 2024?
If
Yeah, no.
then we could do it late August, if that's possible. Judge, I am I just have a vacation in August. I'm trying to not get accepted.
Oh, when are you going on
I
vacation?
will be out of state between the 12th and August 12th and the 20. Yes, between the week of the 14th through the 18th, I will be out of. If we could just knock it, maybe the week after that, would that work for you?
All right. Caroline, on Woodard. Recall this for August 21st for discovery.
Judge, with regard to discovery, I have viewed pretty much all of discovery in the past already. I don't know, I appreciate Mr. Phillips saying he's gonna make sure that there's nothing else out there, but we have pretty comprehensive, all the body camera, all that sort of stuff.
Okay, so what's going to be due on August 21st? You need to be prepared to make an offer and make sure they have all the discovery.
Yes, ma'am. Yes, Your Honor. Thank
All
you.
right.
Thank you, Judge.
Is there anything else?
No, no.
Nothing for the state.
Oh, after you sign the reset form. Then something's going to happen.
Hey, how about your
I'm gonna-
Tigers, the first two draft picks in the baseball MLB draft?
Yeah, and
LSU?
you know what? I talked to Cornelius.
Mhm.
He's not been wearing his Florida hat, but I have not seen him.
What a shock.
Yeah.
I wouldn't wear that thing. It's cool. 30 years ago, it was cool to wear Florida stuff, but not.
He'll be back with his Florida. You can't help himself.
Yeah. So I'm going to say like, Cornelius, where are you? But all right, so you all be back on August 21st.
Yes, thank you, Your Honor.
All right, thank you.
Okay, I'll let you know. I'll terminate it.
Yeah.
Michael Bell, I'm sorry, Michael Ball.
This is ready.
Good morning, Mr. Ball. So today is your plea deadline date. So what's happening?
Oh, Judge, we conferred, get the same offer, we turned down the offer, we're ready for trial.
Okay. All right, and the court has received the acknowledgement of discovery. So you have all discovery, counsel?
I believe so, Your Honor.
All right, your plea deadline date has expired. The court will not accept any plea bargaining agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand? All right. So I'm going to recall you back for jury trial. Family violence, I believe you are the week of August 31st. Is that correct?
I believe so, Your Honor.
All right. So I'm going to call you back on August 1st.
Judge, I have a vacation for that week, if it's possible that we could do, I'm sorry,
No problem.
I apologize, I'd rather do it now than have to work with it. I'm available the 7th, the 15th,
Are you available the week of July 17th?
July 17th,
Mhm.
next week?
Yeah.
No, Your Honor, that's the last week of cheer stunt camp and things like that.
Cheers. Yeah.
I have to make sure that, yeah, dropping everything off. So the 17th and the 31st, those weeks I'll be unavailable, but starting on the 7th, back to actual.
All right. Caroline, let's recall this for August 15th for jury trial. All right. You'll receive your reset form, then you are excused.
Thank you, Your Honor.
You're welcome. Oh, you're welcome. Oh, no problem. Oh, no problem. You're welcome. Who's here on Joe Vincent Vitale? Vitala? All right, come forward. And where's, sure, okay. Who's here on Pierce Jones?
Your Honor, he looked.
All right, Mr. Jones?
Hey, go get my client, Your Honor. He's a mentally ill individual, so I had him on the outside.
No, no problem.
I'll be right back. Just some pictures.
On this?
Is it NPR?
No, I don't have anything.
Take it off.
Okay. All right, thank you. Oh, and Caroline? On this one? Do you have, services office or something? All right, just, I tell you what, just have him wait outside for one more moment,
Okay.
because I'm gonna have pretrial services zoom in, because there's a violation report.
Yes, Your Honor.
Okay. So just give us a moment. You can wait outside.
You just. Just right before you came in, it was black. You just like missed it like a second.
Hey, let me know though, Judge.
Okay.
I don't know if you have time to.
All right, is it off docket?
It's on.
It's on docket? Oh, yeah, just have the file pull.
Oh.
No.
Yeah.
All right, Aaron Bawani.
Judge, he's still in custody. He's been pulled up, but we'd like to approach on the matter of bond.
Oh, okay, if it's a bond, you're asking for what, a bond reduction?
Yes, sir.
Did you file a motion?
So we haven't filed a motion yet, but I wanted to see if we could get a date with Nahara. I could file it. And put it in the council.
Oh, okay,
Is that possible just to get a date certain and then I can?
sure,
I can.
yes. Yeah, just have him brought out, and have you conferred with the state?
Yes, we did.
Okay, all right, just ask for the deputies to bring him out and they'll bring him out.
We're to the court from the judge. Sorry, Marco Morenovacis. Issue.
I don't know. I don't think so, but he probably needs an interest.
Mr. Bawani is.
Okay. All right, have him come up. Can I see someone from family violence, please? Hi. Okay, thank you. State, this is Aaron Bawani. Is that how you pronounce your name?
Yes.
All right. So the defense is going to be asking for a bond reduction, so they want a date certain on this. So I know it's not within the time frame, but State, would you be ready if we brought this back on a Thursday?
On a Thursday,
I mean, the 13th.
I think we could make that happen.
All right, is Thursday okay for you? All right, so you'll still need to file that motion and we'll come back on Thursday, the 13th. I always ask this question of everybody. Well, not of everybody, but are you a citizen?
Yes.
Okay. And is English your first language?
Yes.
Okay, all right, awesome. I thought I was going to be blessed with some different language. Do you speak any other language?
No, English.
Oh, well, okay, that's fine. All right, so what we're going to do is we're going to bring you back on the 13th. So that'll be Thursday, and we'll hear your your attorney's motion for bond reduction. And the reason why it's on the 13th, the state has to be given notice, and the state is waiving their notice because they have more time than just 4 days to prepare for a bond reduction, okay?
Okay.
So that's the quickest we can get you back. Do you have any questions about anything? Questions about the process? All right, so we'll see you all back on the 13th.
Sounds great. Thank you.
All right, thank you. All right. And there it goes again, Deputy Laura.
They're in the back. They swear like, I've been telling them.
Mhm.
They show up, it doesn't do it, and then suddenly they start to do that.
All right, this is for the 13th. And it's going to be for a bond reduction.
That's the last one.
All right, are the parties ready on the tele?
Yes, Judge, if I could just have one more, I'm sorry.
Sure. All right, thank you. Okay, all right, thank you.
No, wait.
Morning. This is all I- everyone there, I want you all to- this is gonna be my- yeah, what, you need an extra line, there are some- Judge, well, I'm back today. We'll walk in. Please confirm to me what exactly you do. Yeah, that's all. Okay. And can you tell me how many days? One. Thanks. Very bar.
Okay. Could I see the parties on Pierce Jones? Then after that, we'll take up Vitala. And you can have him come in. Ms. Vasquez?
Good morning, Judge. Yes.
All right. Are you able to show your video?
Yes. Let me see.
All right. Your video is not showing, Ms. Vasquez. Thank you.
No problem.
All right. So, Mr. Jones, the court has received this violation report, and it's with regards to your GPS.
Oh, yes, I was out at Roosevelt Park yesterday. I was there for like 20 minutes walking. And
Oh, no, he can talk. It's fine. We're not,
Make sure he wasn't cutting you off.
no, he's not. All right, you can continue.
We got a call from, I think it was, I didn't have my phone on me, but, I think we had a call from Miss Vasquez, and they called out, a person from group home to come get me. But I was out there for 20, maybe 30 minutes.
All right. So do you understand what GPS is?
I do not.
All right. So GPS, that means that you're on a monitor.
Okay,
And that means if you're going somewhere, you need to get permission.
okay, all right. I did not get permission. I did not know that. I don't think they told me.
Okay. All right. Well, this is your first violation report, and I know there are some mental health issues that are going on as well,
Yeah,
but you are not allowed to make unauthorized stops. Being on GPS in a way is sort of like being at the jail, only you're out and about.
yeah,
So you have to call and get permission. Do you understand?
yes, I do. They did not tell me that I had to do that. They said, they did say though that I had to stay at St. Mary's, but I thought, I don't know what I was thinking, actually. I don't know what I was thinking.
That's okay. Ms. Vasquez, does he need to call you to get permission to go for a walk in the park?
Judge, if that's something that you would allow, as long as he gives me 24-hour notice, I can have him out on a schedule.
Okay, yeah, that sounds.
Your Honor, with regard to that, I know that he's been out on the CHCS complement restoration for about a little over a week and a half, Judge, and it seems like he had an issue because he does like to go to the park. He also wants to try to look for a job. So that's why we filed the motion to modify to from partial to tracking only. However, if
We're not going to do tracking only.
the court does not see fit, I did also in the order allow, if the court sees fit for him to be able to go exercise in the park or look for a job from the hours of 9 to 11. He has been in custody previously 10 months, waiting competency issues. There was not a bed for him, so I reached out to Center for Healthcare Services. They stated that he didn't meet criteria for that outpatient competency restoration. But my client does suffer with some mental health issues, and he says that being in the park and being able to be out in the sun, it's some vitamin D.
Well, I mean, here's the thing. He will be allowed. State, do you have any objection to him being in the park?
No, Your Honor. We would have an objection to modifying the tracking only, but if
All right,
that's
so
not an issue.
we're not going to do tracking only. Mr. Jones, are you living with someone?
I'm at the 1618 St. Mary's Rio boarding house, but I'm not with anybody.
Okay, so we'll do this in increments, okay? Because I have to make sure that you're following the rules. And so I can't give you, well, I won't give you tracking only because we're here for a violation. So we'll start with you having a window where you're able to go to the park, but you're not allowed to make contact with the complainants. Do you understand?
Yes, I understand.
Right. So before you go to the park, for example, if you want to go out to a park on a Tuesday, let's say you want to go to the park tomorrow, you need to call Ms. Vasquez and let her know, hey, I would like to go to the park on Tuesday. If Ms. Vasquez says yes, she'll give you a time frame of when you're allowed to go, okay? So he'll be allowed to go to the park, but he has to call Ms. Vasquez the day before.
Okay.
All right.
Yes, Your Honor. One further thing, Your Honor,
before we're done with this hearing, is I did speak with the mother, the complaining witness in the
Mhm.
case, Stephanie Jones. She does want him to be on the GPS monitor. However, she requested that she be allowed to assist him. She, for instance, wanted to take him some hygiene products, some clothing as well. But she has a no contact order there, so she's just requesting to help. I know that at the facility too, since Mr. Jones has a lot of appointments with the Center for Healthcare Services as well as free trials. She said that she can assist, but that we need to change the no contact order. But I told her I would address it with the court, and she was working this morning, so unfortunately she couldn't be here. But I do have an affidavit non-prosecution as well. She more so just wants him to get the help he needs, Judge.
Mhm.
Doesn't want him embroiled in the criminal justice system for punitive purposes. But we're all, I think, on the same page, including Ms. Vasquez, which we did meet with Ms. Vasquez and Mr. Jones this past Friday, and we did get more so on the same page. And I think he is coming to understand, Judge, but he does have some lapses there.
Okay, all right, so this is what we'll do with regard to that. The next setting he has for August 17th. If you want to set this sooner than August 17th, just let the court coordinator know. We'll have him brought over and make sure that Ms. Jones is present and confer with the state. I'm sure the state will work with you.
And we'll get in contact with Ms. Jones as well.
Yes, sounds like a plan, Your Honor. I appreciate the court's time.
All right, thank you. So do you understand, Mr. Jones?
Yes.
All right, so if you want to go to the park tomorrow, you need to call Ms. Vasquez today.
Yeah, okay.
Do you want to go to the park tomorrow?
Yes, yes.
All right, Ms. Vasquez.
Would I be able to go to the park tomorrow? Oh,
All right, yes.
Oh, sorry, I'm mentally.
No problem. Ms. Vasquez.
Would I be able to go to the park tomorrow, Ms. Vasquez?
Yes, sir. I just need a time frame.
9 to 11.
Okay, I will go ahead and put in the schedule for tomorrow.
All right, thank you.
All right, thank you.
Thank you, Your Honor.
And on this one, we need an interpreter. All right, Marco Moreno Vasquez.
Ready, Judge.
And then Mr. Callahan, we will take you up next. And Norma, can you call Jason Goss?
Jason Goss?
Yes. Hello, good morning. It's always great seeing you.
It is always my pleasure.
All right, so on this case, where are we with discovery?
It's a first setting, Judge. I'm still downloading some of the discovery. I'm not sure whether they have any of the surveillance videos on there, but after I complete all that, I'll let the DA know.
And Judge, just let you know, it comes up on the docket as a tampering, but it's actually a murder game.
Yeah, it's really confusing because on the
I think
D page, it shows tampering, but it also mentions, it says felony 3, and then like 2 entries above it, it says murder. I couldn't find anything showing murder, but the indictment does have murder.
I think what happens is the intake division, when they file it, they put tampering, probably one of the last things, and they change the actual. But this is a co-defendant murder that was set on July 7th. And so it is a B, and there's an A co-defendant.
All right, have we reset the A case?
Yeah, I believe I just looked, I think it says August 3rd.
All right, Ms. Ferguson, can you look up the cause number 2023 CR 4371A to see when that is set?
Actually, I thought A was my guy. I thought it's B is the other guy.
No, they have you listed as B.
Okay, my fault. In this case, I'd rather be.
August 3rd.
All right, so we'll come back on August 3rd.
Sounds good.
All right, is there anything else?
Nothing from state, Your Honor.
Nothing from defense.
All right, so Mr. Moreno Vasquez, you're using an interpreter. Are you a US citizen?
No.
All right, Norma, there needs to be an immigration attorney as well. Unless you, I know the answer for murder, but. So Norma, if you can make sure he has an immigration attorney.
That one's pretty easy.
Yes. Is there anything else?
Nothing from the state, Your Honor. Nothing from the defense, Judge.
All right, thank you so much.
Your Honor, may I be excused?
Yes, thank you. Have a great day.
You too.
All right, can I see the parties on Batala? Mhm. Sure. All right. Whoa. That's some feedback. All right. Am I understanding he pledged 2 cases? Is that correct?
Yes, ma'am.
All right, court is calling 2023 CR 3033 and 2023 CR 3036, State of Texas versus Joe Vincent Batala. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
For the defense?
Danny Callahan.
All right, and are you Mr. Batali?
Yes, ma'am.
All right, in each cause number, you entered a plea of no contest to aggravated robbery. And each cause number, the plea bargain agreement is to be assessed at a cap of 10 years in the prison. The state opposes your application for deferred adjudication. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, any objections to the PSI report? State?
No, Your Honor.
Defense?
No, Your Honor.
All right, any witnesses? State?
No, Your Honor.
Defense?
No, Your Honor. Allocution.
All right, state to your post?
Yes, Your Honor. Could I reserve until after the defense, Judge, or?
No, I mean, whatever evidence you want to present to the court as to why you're opposed, and then the defense will go.
I just have argument, but Judge, we're opposed to the application for probation. The facts of the incident, like the cases that the defendant is pleading to today are knife robbery at a McDonald's, which is an inherently scary offenses, Judge. The state did take 2 of those into account, Judge, and we think the 10 years is reflected is a fair sentence for that, Judge. I know you've had an opportunity to look at a TAP evaluation, but the defendant's criminal history is on page 2, and I see a pattern, and it's escalating criminal history, starting with juvenile, moving on to misdemeanor to felonies. He also has assaultive a couple of ABIs outside of the county, Judge. Also on page 5, the victims were of the TAP evaluation. The victims have told probation that they were scared. Of course, being threatened with magnets is a scary thing. They're seeking medical attention, some sort of counseling to help them deal with that. Also on page 7 of the TAP evaluation, I don't think I can say it any better than the victim said it. He's obviously not a good candidate for probation, Judge. Also on page 11 of the TAP, towards the bottom there, he's really, the defendant is minimizing his culpability. He's not recognizing that these are choices that he made. It says, I was on the Xanax and methamphetamines that day, so I honestly don't remember what I was doing. This is not somebody who's taking responsibility for their actions, Judge. This is someone trying to minimize their culpability. When asked why he felt he should be granted probation, the defendant said, because I really don't want to go to prison. I'm not meant for that. Judge, this is not somebody who's taking responsibility for their actions. We're asking for the 10 years, Your Honor.
All right, defense.
Your Honor, the PSI reflects the root of these problems are threefold. He's got a mental illness, got a 7th grade education, he takes drugs. You can fix all those problems with an intensive supervised deferred adjudication and a McMile supervision. I ask that you award 10 years deferred adjudication. Moment, please, Your Honor. Nothing further, Your Honor.
All right. Did you wish to say anything or no?
No, Your Honor.
Okay. All right, the court has reviewed the PSI report. I always reread the stipulations, which in this case, Mr. Vitala is the police reports and everything that was submitted to the court. And it does appear from the PSI report that you're continuing with criminal behavior. As I look at your PSI report, you had juvenile cases. And then you have cases as an adult, the discharging of a firearm, unlawfully carrying a weapon. And in those cases, you had a motion to revoke filed against you. And then we have another unlawfully carrying of a weapon in April of 2020, evading arrest or detention in September 2021. And then your felony cases, the unauthorized use of a vehicle, and then we have the aggravated robberies. And I understand when people have mental health issues, I understand when they have drug issues. But that's not an excuse. That's more medication. You understand? All right. I don't believe you'll be a good candidate for probation. So in each case, I'm going to find you guilty. Would anyone like to speak with regards to the cap? State you're asking for the 10 years?
Yes, Judge, I feel like the 10 years is an appropriate sentence based on the severity of this crime. This was a robbery with a knife, Judge. It's pretty scary. I think as the judges pointed out, as you pointed out, Judge, it's escalating behavior. So it starts as misdemeanors and then it goes up to these more and more dangerous activities, Judge.
I suggest to the court 6 years, Your Honor. There's no evidence that he's misbehaved in jail, that he hurt any police officers when he was arrested. He was cooperative with this court and with probation.
All right. Does anyone want to speak with regards to restitution?
Whatever the court orders, Your Honor.
Judge, the TAP evaluation indicates that there's restitution to Jathan Cantu on page 5. It's JATHYNCANTU of $120.
Defense, do you have any objection to that?
No objection.
On page 6, it's restitution to Alan Hernandez of $1,078.
Any objection?
No objection.
There's no restitution on page 7. There's no restitution amount for the other victim. The third victim is Ali Sefraoui, ALI, and then the last name is SEFRAOUI. So I've just asked that the court order restitution to be determined, Judge.
All right. With regards to the restitution to be determined, the court is not going to allow that. This case has been on the docket since May, awaiting for restitution. And I find that when you say restitution to be determined, what ends up happening is somebody could say they want $30,000. And then Mr. Vitale, though he's done wrong, he won't have an attorney to address the issue of the $30,000. And somebody will just put that and it'll take a while to clear that up.
Yes, ma'am.
All right.
Well, there's one final complaining witness, Judge. Sorry, on page 8, Damian Ortiz, he said that his monetary loss was $250, Judge.
Any objection?
No, Your Honor.
Mr. Vital, your attorney is telling me that you have mental health issues and that you have drug issues. If you would like, the court could recommend the therapeutic community for you. It doesn't increase the time that you spend at the prison, but they can help you if you so choose. So would you like to be considered for the therapeutic community? All right, you'll still have to ask for it though. All right, and cause number 2023 CR 3033, the court will find you guilty, sentence you to 10 years in the prison. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 3036. Take in consideration 2023 CR 3034, 2023 CR 3035. There's to be restitution of $120 to Jathan Cantu, restitution of $1,078 to Alan Hernandez, restitution of $250 to Damian Ortiz. And cause number 2023 CR 3036, the court will find you guilty, sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 3033. Take in consideration 2023 CR 3034, 2023 CR 3035. There's to be restitution to the following: $120 to Jathan Cantu, $1,078 to Alan Hernandez, $250 to Damian Ortiz. And in each cause number, the court will recommend the therapeutic community. Is there anything else from either side with regards to sentencing in either cause number?
No, Your Honor. No, Your Honor.
All right, showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in both places? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction in each cause number, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Are there going to be victim impact or no?
No, Judge.
All right, so here's the thing. How old are you? 28. 10 years is a long time. I personally think any time that you're confined is a long time. I remember when I was a defense attorney, people would make an offer to my client and they'll say, oh, they can do 2 years standing on their head. And you know what I would always tell the person? Have you ever done time? Until you've done time, you can't say that. So I realized that every single day locked behind bars is a long time. But you're going to have to do better. I see that you have children. If you don't do better, you know what's going to end up happening? You're going to end up spending the rest of your life at the prison. You understand? So I'm giving you a chance to take advantage through the therapeutic community, and you got to do better. Otherwise, you're going to be the grandpa at the prison. Don't be that person, okay? All right, good luck to you. Could I get the dismissals?
Yes, ma'am.
Yes. No, he has 2 dismissals.
Oh.
And that's in 3034 and 3035. It's always good seeing you, Mr. Callahan.
Your Honor, good to see you. Be seen.
Yes. That's what people always say. It's good to be seen. And Caroline, they're going to submit the dismissals.
You have to excuse your Honor.
Yes. Do you want to wait for your dismissals?
Sorry about that, Judge. I'm just going to check these real quick.
No problem. Are the parties here on Chardonnay Lockhart? Hi, we're waiting for your attorney, okay? Yvonne Perez. Good morning. If you have your client come up. All right, so on May, I saw that the autopsy was completed. So where are we on this case? This has been going on since January 2023.
Yes, Judge, we received an offer today. Ms. Perez is not accepting the offer at this time. So.
Oh.
Yes, we put, so
I'm going to give you a reset date for a plea deadline date. So in this court, Ms. Perez, there is no, I'm not accepting the offer at this time. What ends up happening is I give you a plea deadline date. On that date, you need to let the court know whether or not you're accepting the offer. You understand? If you choose not to accept the offer, then the court will only accept a plea bargain agreement for good cause. Otherwise, you have to plea open to the court. You understand? So in this court, people are not allowed to come in on the day of jury trial and they see a jury and they say, oh, I'll take that offer now. That's not the way it works in this court. You understand? All right. So let me see. Norma, can we recall this back for July the 24th for a plea deadline date?
Yes, ma'am.
All right. Do you understand what a plea deadline date means? All right. Do you understand what that means? Well, let me explain it to you. The state has made you an offer. I don't want to know what the offer is because your attorney is saying you're not accepting that offer. So the state has made you an offer. I'm going to give you a chance to think about it. So you're going to come back on July 24th. On that date, you're going to let the court know whether or not you are accepting the state's offer. If you choose not to accept the state's offer, then your plea deadline date will have expired. So what that means is, let's say 3 weeks from now, or you're set for jury trial. You see a jury come in and all of a sudden you lean over to your attorney and you say, I want to accept the state's offer. Court is not accepting any plea bargain agreements after July 24th without good cause. Otherwise, you have to plea open to the court. Do you understand? So the range of punishment on this case, I believe, is up to life in prison. So that would be your range if you were to plea open to the court. You understand? You have any questions? Okay. Are you not able to speak loudly enough?
she can, she was very like.
All right. No, she'll need to speak up because if I can't hear her, then
I understand.
yes. All right. So do you understand everything? Do you have any questions about anything? Oh, sure. You can speak to your attorney. We'll put you in the box and you can speak to your attorney. All right. Thank you.
It would be excused from there.
Yes.
Thank you.
Did we get a date for the plea deadline?
It's July 24th.
Okay.
And Mr. Callahan, here are your motions for dismiss.
Why? I know. Well, this time. Big judge. All you're in front of the judge. But yet in the state file, I find this unexecuted. You know that? Yeah. Okay, I just want to make sure you got everything.
Are you ready?
Then the extra red.
That one's in doing.
Okay. And where is Mr. Goss?
Apply for probation and. Paperwork's not ready yet.
Yes, yes. If you'll have her come up, please. Hello, Miss Lockhart. All right, Miss Lockhart, we're going to bring you back on July 27th. My understanding from probation is you have an appointment with them on July 20th, okay?
Okay.
All right, so we'll bring you back on the 27th to see where we are. Yes.
One other thing, Judge, we talked about mental health.
Mhm.
Which she apparently told somebody in the system that she's not interested. She is interested in mental health work. She and I have discussed that today. She understands a little bit more about health work and part of your probation. And I think that's a fantastic program.
Okay.
I would highly recommend that she either be rescreened or whatever she.
Well, here's the thing. You have to discuss that with your attorney and counsel. If you want to speak with mental health court and talk to them, you can. And they will have your client with you on that at that time. If you want to be there with her for the interview. All right.
Okay, can you restate with you? Okay, so probation.
Probation is going to come visit you on July 20th because that's when you're scheduled for your next evaluation.
Okay.
And then we're going to come back on July 27th because I will have that report so I'll know what's a good placement for you.
Yes.
All right. So do you want to go to mental health court?
Not,
I mean, you can discuss it with your attorney, okay? Now, here's my other question. Why is her outfit dirty? I mean, this is not, I have dirt that just won't come out of an outfit. It's dirty. Does anybody know why her clothing is not clean? Are they not doing laundry at the jail? I mean, am I the only person seeing this, that her outfit is dirty? I mean, were you crawling on the floor or something in your outfit, or did they give that to you like that? All right, so we're gonna have to, I'll call the jail and see what's up with laundry. I mean, I know they.
Yeah, I think you did what you say too.
Your sheets are dirty too?
Where are they keeping?
8.
I mean, is it just regular? So. It's GP. So no, it's GP. So
All right, so I'll call over there and see what's going on with the laundry. I think they have the trustees to do laundry. Okay, I'm sorry.
It was making me itch.
Okay, well, here's the thing. As I tell people, when you're at the jail, you're not going to get the detergent and then they're going to put some Downy in the rinse cycle or sheets. Your detergent just says detergent. The soap just says soap. So, but I'm going to check on that at the jail. And so you're saying sheets are not being washed and the uniforms not being washed?
Yeah.
Okay, all right. I will talk to the sheriff about that.
Thank you.
And I'll talk to the sheriff about deputies being worked overtime, but that's all I can do is put that out there. All right, is there anything else?
Your Honor, if I may.
Yes.
If we're going to re-refer over to mental health court, I'll just give you an order to sign.
Yes. Okay, but that won't interfere with her scheduled 20th date.
We're gonna keep that date as well.
Okay, all right, so your attorney is going to talk to you about mental health court. So we can't do this thing where you tell them you're not interested and then we do this back and forth. We don't do that, okay? So your attorney will speak to you about that, but I will see you back here on the 27th. Yes, and I'll talk to the sheriff about the outfits and the clothing.
Thank you.
You're welcome.
Sure.
All right, Lutrell Miles, is he in custody, Norma?
Oh, yes, yes.
All right, recall him for the 13th, since his attorney is in federal trial. State, this was a plea that was entered, but on Miles, his attorney is in federal jury trial. So he's asking for it to be recalled for July 13th. So we'll be back at that time. Bashan, Miles is going to come back on the 13th. Who's here on George Ibarra?
I am, Your Honor, we're ready.
Okay. Hello, thank you for coming and thank you for dressing appropriately for court. All right, court is calling 2023 CR 3055, State of Texas versus George Ibarra. Can I have parties announced for the record for the state,
Hank Wilkins for the state, Your Honor.
for the
Ken Wong,
defense?
Anchor, Mr. Ibarra.
And are you Mr. Ibarra? All right, Mr. Ibarra, you entered a plea of no contest on June 20th. The court found there was sufficient evidence to find you guilty. The court found you guilty, and you were reported here today for sentencing. And I appreciate that you came in knowing that you were going to be sentenced to do time. So before I sentence you, is there any drug issue on your part? Because I see this as a possession less than a gram case.
I've had issues before.
All right. So what I can do is I can refer you to the therapeutic community if you wish to be referred to the therapeutic community. It's held at the prison. It doesn't increase the length of time that you're in custody at all. Would you like that? Okay. All right. The court is finding you guilty as previously stated. The court will sentence you to 11 months in the state jail facility. Court will give you credit for any time served. Showing you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, no, that's yours for your client. And because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So, Mr. Ibarra, when you get out, go do some sober support meetings. Don't get caught up in this. Otherwise, you're going to find yourself in and out of custody. You understand? And with regards to drugs, you never know if you're going to end up with a bad batch. And the last time you use may be the last time you use. You understand? All right, good luck to you. Thanks for showing up.
Thank you, Your Honor.
All right.
Excuse me?
Yes.
Thank you.
Sure.
All vouchers are now e-filing.
Are you ready? He's downstairs.
Are you finished? Just wait, that's motions, I'm waiting for a file. Mine goes to morning, this morning. Yeah. And I filed a motion to withdraw.
Hello.
Hey, Your Honor, I haven't seen you in a while.
All right. How's it going?
Pretty good, pretty good.
Oh, who are you here for?
Advocate Sanchez.
Yeah, Judge, they haven't brought him up yet.
Oh, they haven't brought him up. So just give us a moment.
About the motion to withdraw, I'm down in the 399, the trial, it might be us starting over there or one of the.
Okay, if it's starting, we'll reset it. It's not a problem. All right, so just check in. And if you started the trial, just let us know.
Okay, and the motion to withdraw, I haven't talked to him since this was over, he contacted the family, because the family also has supported me, and I tried to tell them to get the pounds.
Okay,
And so,
well, we'll wait for your client to come out.
okay, then, thank you.
All right, you're welcome. Okay. I thought he was in jury trial. Okay, all right, thank you. Yes.
I don't have Mr. Cox.
Okay.
Louis Rebus is a finding piece last June, I think. Last stage there. I can't recall the conversation, so I guess I would be more honest. It was the wrong of the idea, so we'll do it tomorrow on.
Is he in jail?
He's in country with us. One of the other ones.
Bruce Rivas. Oh, did you request him? Did you request Mr.
No,
Rivas?
Judge, I just asked the court to set it for a trial, Judge, but he's in the back. I did not request him to be out here right now. But
Yeah.
I can, Judge.
Yes, okay.
Thank you, Judge.
He's on. Rodriguez?
Don't know that that's.
Heroes?
Angel Guevas.
Judge, he's another one of my clients, but I'm gonna take care of this, Judge.
They're not ready.
Yes, sir, we're not ready.
Yeah.
Sure.
Okay.
Yeah, Rick it is. Yeah, Rick it is.
He used to travel to do some training. Bobby knows I haven't talked to the state yet.
Well, let's wait until.
It's finalized.
Okay. You need to. Are you still working for the now?
Yeah, well.
Okay. You'll work on different.
Yeah.
Okay.
I'll let you know.
Okay.
We're on top of it.
Yeah, thank you.
Okay.
And then I gotta give the judge congratulations. I'm on approach right now.
Hi, what am I being congratulated for?
Not you specifically, but your alma mater.
Oh, yay.
College World Series. Huh?
Yes. And you know, after the 24-4 loss, I can't imagine. The only good thing about having a loss that big is there's sort of nothing to say. The only thing you can say is, you know what, we're going to move past this. We got another game to prepare for.
What else can you do?
Yeah.
Yeah, 24 to, what was it?
I think it was 24-4,
4.
that
In
second
football,
game.
That's
Yeah, it's like,
okay, but in baseball, that's a royal something.
well, in football, you're trying to figure out, okay, where did they get that 1 point for? Or did they do
Right.
a lot of touchbacks? What's going on?
Right, well, actually, it could be, if it was 24, then it could be 3 touchdowns
Mhm.
and a field goal.
Well, no, I'm talking about the 4. You know, the 4 points. In
Oh,
football,
the other
yes.
4, yeah,
Yes.
yeah.
Like, where does that come from?
Yeah, that would be. Yeah, where would you get that? in football?
Well,
I mean, a touch,
you can do a
safety,
touchback.
2
Yes, you can do 2 safeties.
or 2 safeties.
Yes.
That would be about it.
Mhm. So we shall see. We shall see.
So anyway, we've got next month.
Okay.
Starting it up, SEC.
Yeah, we'll see how it
And
goes.
then Texas will be in there next year.
Yes.
So that'll be interesting.
Yes. All right. Who's here on Anthony Cantu? Anthony Cantu. Who's the attorney for Anthony Cantu?
Oh, it's Mr. Fowler.
All right, just have a seat.
Did my average to the challenge.
Oh, no problem. Oh, no problem. Can two? And probation, this is no application. Court is calling 2023 CR 1044, State of Texas versus Anthony Ray Cantu. Could I have parties announced for the record for the state?
Hank Wilkins for the state. Andrew Fraley. Cantu.
Are you Mr. Cantu? Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 18 months in the state jail facility and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing it, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions? Next, I'm showing you outside the plea bargain agreement. State is asking for no contact with the complainant in this case. Did you understand that's a recommendation from the state and the court does not have to follow that recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, I submit State's Exhibit 1 and attachments.
No objection, Your Honor.
All right, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, can we go off the record for a moment? Could you mute us, please? All right, we are back on the record. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, sentence you to 18 months in a state jail facility. There's to be credit for any time served, and there's to be no contact with Leonard Hernandez.
Judge, I could, my client is 44 days and I want to make sure that you agree to give him credit for any time served. And second, any diligent participation in the state jail. Not sure if you did a presumptive diligent participation or whether you would do that afterwards.
Oh, they'll send a form to me. If you're actively participating and availing yourself of the programs that are there to help better yourself, and hopefully you won't come back before a judge, then the court will strongly consider giving you that. And what I can tell you is I usually do give that when I see that people are taking advantage of the programs that are offered. All right. Okay.
Thank you very much.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And I'm sorry, what was your plea in this case? Was it no contest? All right. All right, and because this is a felony conviction, you're not allowed to own any weapons or ammunition. Do you understand?
Yes.
All right, we can go off the record. How old are you? You're gonna have to do better. Do you have children? Okay, that's a good thing. You got to get your life together, then start working on other things. You understand? Don't come back here. This is foolishness, okay? All right, good luck to you.
Thank you.
Whoever did your tattoos did a good job, by the way. Eros Rodriguez. All right. Hi, you're over there. All right, what is happening on this case, counsel?
Judge, we have. It's CT. I conferred with Mr. Garahan this morning, Judge. We're going to continue to confer. We are not at the resolution. I'm asking the court to give us another reset vote, Judge. I believe it's our initial appearance post indictment.
All right, do you have all the discovery?
I do.
And has an offer been tendered or no?
Not yet. Mr. Garahan indicated he was going to review it and email me one in the next few days.
All right, Ms. Ferguson, can I have a 30-day reset on Eros Rodriguez?
August 14th.
I will.
Are you going to be in Europe?
Even if I'm going to be in Baton Rouge for a month.
Oh, look, he's, yeah, you're throwing that
I
out.
will not be in Europe, but I'll be continental, but I won't be in town.
All right, so when do you leave?
The 7th. I believe we arrive back that day. 7th. The 14th is what you said?
Yes, August 14th.
Yes, anytime after that, but before the 29th of August.
All right, what date, Ms. Ferguson? All right, we'll see you back on August 17th.
Thank you, Judge.
At that time, the state will give you an offer.
Thank you, Judge.
All right, just get a reset form from Ms. Ferguson, then you're excused. Parents Truesdale?
Give it 1 second on that.
Okay.
I'll let you know. Sorry about that.
Oh, no
I
problem.
need to talk to the prosecutor one more time.
Okay.
Thank you.
Taking my family, including my daughters, to Las Vegas next week.
Well, a family that gambles together stays together. But you know, you should try this place and
They're not allowed in the casinos, Judge.
I know. You should try this place I went to one time. What is it called? Serendipity?
It's closed.
They closed Serendipity?
Serendipity 3.
Oh my gosh.
The owner went to prison. Yeah,
For what?
but I agree. It's by Caesar's Palace. It's
Yes.
amazing. It's amazing.
Yes.
It
What did
really
you go
is.
to prison for?
Financial crimes.
They had a
Could
great
handle all
dessert called
Oh.
Strawberry Fields.
Oh, yeah. I've been there before.
Yeah.
I know it's really, really good.
Well, I need to stop every time people go, I'm like, go to Serendipity.
No, it's gone.
Are all of them gone?
Google it. It's an interesting story. The one in New York, I believe, is. Thank you, Norman.
I'm gonna have to Google that then.
Yeah, it's sad. I'll let you know how it goes, though. Wish me luck.
Okay, will do. I know I gave it back.
Yeah, sorry about that.
Yes. Parents Truesdale. Where's the attorney? Oh, there you are. All right, so today is the plea deadline date?
Yes, it's my understanding, Judge. We just received a plea offer right now. We're just asking the court to keep us in the trial docket. There are some additional discovery matters that for some reason I couldn't download, but we got that figured out. I downloaded them right now. They'll probably be ready in a few days.
Yeah, Judge, so I uploaded the documents that a defense counsel needed, but I didn't click a box that made them discoverable, so you could see that they were uploaded, but you could not view them, but now he's able to view them.
All right, Ms. Ferguson, on Truesdale, recall this for 3 weeks for a plea deadline date. I'll extend it because you were unable to download the discovery.
Thanks, Judge. Thank you, Judge.
I can do August 8th.
That works, sure.
All right, so after you sign the reset form, your client is excused.
Yes, ma'am. Thank you, Judge.
You're welcome. And counsel, your client was late.
Yes, ma'am. I talked to him about it.
All right, do not be late again. You understand?
Yes, ma'am.
Okay. Who's here on Mark Anthony Rodriguez?
I am, Your Honor.
All right. And if you can have him come up.
Yes.
All righty, so where are we with regards to jury trial?
Your Honor, I never signed a
discovery acknowledgements. This was Raymond Martinez's case.
Okay,
He had about 13 settings, trial setting with Raymond Martinez. This is my first true setting.
okay,
I do have a discovery issue. I emailed Bill Ray Garcia last year.
okay,
And I talked with Brittany Sparks twice, but they're no longer in the office. Spoke with Hank and Jason Garahan.
Mhm.
They're gonna look through the videos. They're also gonna try to contact the complainants. I proposed a counter offer.
okay.
And I think that we may be able to possibly work something out. We're asking them, I don't know if they would give us 30 days, but
Okay.
we're asking time for the state to look for two things.
All right, Ms. Ferguson,
Yes, ma'am.
on this case, can you recall this for 30 days? And that's going to be the plea deadline date. The court is not going to extend it any further.
Yes, Judge.
August 15th.
All right, August 15th.
Thank you, Judge. I appreciate it.
All right, you're welcome. And thank you.
Rodriguez?
Who's here? Larry Berry?
I'm present for him, Judge. We're ready.
Okay. And probation, this is an application. Court is calling 2023 CR 3443, State of Texas versus Larry Everett Berry. Can I have parties announced for the record for the state?
Hank Wilkins for the state yard.
Defense?
Kenton Longacre for Mr. Barry.
Are you Mr. Berry? Counsel, have you received all the discovery and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Berry, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it and did you sign it? Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge, except we're waiving the enhancement.
Any objection?
Not at all, Judge.
Mr. Berry, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Certainly have, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am, I believe he does.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 16 months in the state jail facility. There's a $2,000 fine. State opposes your application, and there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, I submit State's Exhibit 1 in the attachments.
No objection, Judge.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. This will be set for sentencing on September 7th. The reason why it's such a long date is because there's a slight backlog. Probation, I'll need a PSI and a TAP.
Your Honor, excuse me, Your Honor.
Mhm.
I'm set for trial in 144th beginning on September the 7th. Could it be another day?
Well, we'll see where we are because I don't know. It may be done sooner than that. So we'll just see where we are. We're going to keep the September 7th date. Then if you're in jury trial, then we'll move it to a different date.
Thank you, Judge.
All right. And I'm going to want a TAP evaluation. And you can do a referral to felony drug court. All right, Ms. Ferguson, we'll give you a reset form and we will see you back on the 7th. On September 7th, I'll make a decision on your application based upon the PSI report I received and any other evidence that's presented. All right.
Thank you.
Thank you.
Maybe excuse.
After he signs the reset form.
Yes, ma'am.
Orlando Cuevas. All right, if you come forward, please. Hello.
Hi, Judge.
Hi. So where are we on these cases?
We have conferred, I was relayed an offer.
Okay.
State, and I have conveyed the offer to Mr. Cuevas. Mr. Cuevas has a couple of pending felonies in Rio County, set next week. And he is being picked up Friday to go there. We're asking for a 20 reset to see what the results of that situation are.
All right. What are the charges, the alleged charges in the other county?
Being arrested in motor vehicle and aggravated assault with Indian.
Okay.
It's 1 and that's supposed to 1 2.
Yeah.
1 that's supposed to be dismissed. I got put one there.
All right. And so which one you think is going to be missed? I'm sorry, dismissed?
The 1 and that's supposed to.
Okay.
And I will keep track of that, Judge. But we do have an offer and
Been going back and forth that's a couple months of them.
Okay. So Ms. Ferguson, on this case, we're going to do a plea deadline date for 30 days.
August 15th.
All right. Do you have anything set on August 15th in the other counties?
I have on the 18th and 27th.
All right. So just the 18th and 27th of this month? All right. So Norman, can you push it just a little bit past August 15th? Because I don't know how long it's going to take for them to bring him back here.
You want me to do August 29th, Judge? Is that too far?
I think that may be too far.
22nd?
22nd?
Yeah.
All right. We're going to bring you back on August 22nd.
Thank you, Your Honor.
All right. You're welcome. Is there anything else?
No, Judge.
All right. We'll see you back then. Thank you. Nancy Zavala. Oh, you're doing the paperwork? Okay.
Yes, if I may.
Yes.
We do have a plea, 1244, TIC, two other enhanced cases. This is a enhanced case.
Okay.
It should be going in for 90 days. On the 1244, we would like, if we could, to bifurcate it, and do the plea today and then do sentencing in a week or two, to give her a chance to get
Okay.
her. fair.
All right, I'll consider that once I see what the case is about.
Okay.
All right, thank you. Thank you. You're welcome. Wilbert Villamiel. Counsel, did you complete your trial? How did that go?
I did.
Okay.
I quit.
Oh, well, congratulations. Oh, yes.
Yes, complete on Friday.
Okay.
On this case, Judge, the last we were here, the court declined to follow the plea, offered the client 20 years. We are respectfully, we have given the court reporter payment for the record, and we are going to respectfully file a motion to disqualify the court in this proceeding.
Okay.
So.
So are you, is your client not accepting the 20 years?
My client is not accepting the 20 years as it's been offered by the court.
All right. All right. Ms. Ferguson, can you put this on the jury trial docket, please?
Your Honor, I've been informed that it will take 4 days for the record, including this one. And so.
Well, whatever date, the first date of jury trial, that's the date of jury trial.
Understood.
Okay.
Thank you. Oh. Your Honor, may we put this on the record?
Oh, after the coordinator comes in for jury trial night?
Yes.
Hi, Ms. Ferguson, on this case, I need a first jury trial available for this case. All right. All right, court is calling 2023 CR 0543, State of Texas versus Wilbert Villamiel. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Villanelle.
All right, we were here on July 6th for a plea. The court would not accept the plea. The court informed both parties that the court would accept a plea of 20 years. Defense?
Yes, Your Honor, we wanted to respectfully inform the court that if our intent is to file a motion to disqualify the court from this proceeding, and that at this time, the court's offer of 20 years to the client is rejecting because we are waiting for that motion. We have tendered a check to the court reporter in order to get the record. And then once that record is received, we'll file the motion and go along that process.
All right. Well, your plea deadline date has expired, so the court will not accept any plea bargain agreements in this case. Your jury trial is set for August 8th. And whenever the court reporter is finished with the record, the reporter will be able to give that to you. I do know that there's a backlog of records that she has from out of Houston and for the fourth court.
Yes, sir.
All right. Is there anything else?
No.
All right. Thank you. See you back on August 8th for a jury trial. Ms. Ferguson, can you give them a jury trial reset, please?
Yes, ma'am.
Yes.
Check it through with Mr. Garrett here on
Mhm.
You gotta do the work. I just can't
Okay.
find judgment.
Okay, okay. Oh, you didn't sign.
At me.
Okay. This is just for employment though, correct?
Only for-
Okay. There you go.
Judge, I appreciate you.
You're welcome.
And again, I do this.
Marco Caliandris.
Good morning, Judge.
Good morning. We're here for discovery. Come forward, please. Yes,
The last trial setting, you signed an agreed blood test discovery order.
yes.
And I was given notice last week that it was available for pickup at the fourth floor window. I went to pick it up. It wasn't available. So I let Mr. Wilkins know. I'm gonna follow up and see if I can find that. But we're asking for a plea deadline for 30 days.
All right, do you know where it is?
No, ma'am, I looked in JD, the last sort of note in there is that they were going, or Daniel was going to request the DPS discovery. I'm not sure, Judge, I'll.
So do we know if they actually have it?
I got notice that it was available, and so I'm thinking the paralegal or the liaison, it's in transport to the fourth floor window. And I checked on Friday. I have not checked today, Judge, so I'm gonna go check today to see if it's available.
So we do know that the state actually has it.
My understanding is I think they have it, because I got notice that it's available.
All right, Ms. Ferguson, you're gonna have a plea deadline date for a month. Have you already extended the plea offer to them or no?
No, I'm not.
Oh, okay. So Norma, on this case, recall it for discovery for a month, please.
I can do, August 17th.
All right, so we're going to come back on August 17th. At that time, we'll see what a discovery is and state you need to be prepared to make an offer on that day.
Yes, ma'am.
All right, thank you.
Thank you, Judge.
Sure. It's Marco Calendres, and he needs to sign a reset form.
Yes, ma'am.
Cruz Rivas. All right, what is happening in these cases?
Judge, we had been conferring since the last setting that we had in this courtroom, but I was conferring with another prosecutor who's not present today. Apparently nothing was written in the system memorializing the offer that I relayed to Mr. Rivas, who was ready to accept that particular offer.
All right, have you talked to Hank and Mr. Gerhan?
Yes, Judge, I have spoken with the prosecution. Again, since there isn't anything memorialized, I don't feel like or he was willing to move forward with that representation that I made as far as that's concerned.
Yeah, Judge, I'm sorry, Judge, good morning. The defense counsel told me that Daniel made an offer that they rejected, and the next day said they wanted to accept, but I don't have any record of that, Judge. So
Okay.
the only offer is a different offer that they're uninterested in taking
Okay, all right, Ms. Ferguson, when is Daniel coming back?
tomorrow.
All right, can we recall this for tomorrow?
Sure.
Tomorrow?
Judge, that's fine. I'll be in the 4:37.
All right, we'll see you back here tomorrow. Is there anything else?
No, that's all we have for Mr. Rivas.
All right, we'll bring you back tomorrow, okay?
Okay. Yeah. No, but I. Thank you, Norman.
Angel Guevas?
Judge, he was outside and he was throwing up. So I didn't want to be around him. So I asked him.
Well, they say COVID is making another round.
This is our first setting, Judge. I spoke with Miranda, and she needs to look at the case closer to determine whether or not she's going to be dismissing this case.
All right, who did you speak to?
Miranda?
Oh, okay. Okay, this is just for division.
Yes.
All right, Norma,
Yes, ma'am.
on Cuevas, can you recall this for 1 month, please?
Yes,
And that'll be discovery to make sure everyone has everything.
Yes, Judge.
I can do August 15th.
All right, we'll see you back on that on August 15th.
Thank you, Judge.
You're welcome. All right, who's here on Kendall Blunt?
Brittany and I've been speaking, I don't know where she went. Oh, here she.
Okay.
And that one's off docket, good.
Yes.
Okay.
Yeah, this is off docket.
Judge, I think we're set tomorrow.
Yes.
It's trial setting. I have surgery on Friday. It was
Okay.
rescheduled from a date that it got canceled and it was not my control. So that's when the
Okay.
hospital said I could do it. So I don't know if we need to look at calendars or, I know he's been in for a long time.
Yes.
It's summer, so
All right, Ms. Ferguson.
I think we convert about the 22nd. Is that the date? I think we were talking about October at one point.
All right, if you all want to confer with Ms. Ferguson, how long is this jury trial going to last?
4 or 5 days. Yeah, 4 or 5 days, that's what I would say.
All right. Any 13-hour videos?
Yeah.
Okay. So,
No,
yes.
If the video comes in, it's not that long.
Okay. All right, Ms. Ferguson, can you confer with them on a jury trial date?
Thank you.
You're welcome. Oh, I haven't done that. Oh, have I done, what's the name on that one? Oh, yes, I did that.
Yeah, that's a very good question, that first week. Not stay. We could be 11%.
Ah. Hello.
If we get another one, Pat, income on that, because on the 12th, which I could redo to the first one. Yes. Just don't want to switch our resets, but we got it all set. Yeah. I mean, I don't mind, taking on the, but I just don't want it to. But I got stuff. The 22nd. No.
Oh, that's what it is, right? Okay. I was doing something. I know I'm wrong. I was saying I'm wrong.
Yeah, that would be a murder.
I do know this. I do know.
Three 57, 97, 22nd. 57, 24. For the 97, it's 107.95. And for the 57.24, it's 107.97.
Hi.
Judge, can I ask a question?
Sure.
Is it all right to write in a waiver number here, or do you want us to actually print this?
Oh, you can write it in.
Okay.
Yes. No problem.
It's going. I've got on my calendar.
Do you guys have a date yet?
The 22nd.
Okay. All righty.
That's our best bet. Can't schedule around.
All right, and you'll let him know, Mr. Blunt?
Yes, I will make a Jill visit and we
All
need to
right.
go over some stuff anyway.
Okay, thank you.
Thank you.
Christopher Morrison. Hello, where are we on this case?
And Your Honor, we need to see if we can get a referral to mental health board if we could.
Okay. All right. And where are we on discovery?
Well, there's still some discovery that I think we need to have from the state as far as the mental health issues that were observed at the time. I think there was a mental health evaluation that was finding in the jail. I just want to see that. But it is a case that I think both sides believe is appropriate for a mental health evaluation, for the mental health treatment.
Okay, so other than the mental health, I guess, discovery that the state has, is there any other outstanding discovery? Is that it?
I think that's it, yes, ma'am.
Okay. All right, Ms. Ferguson, can I have a 30-day reset on Christopher Morrison? Is there an issue of competency or no?
No.
Okay.
So how do we get referred to the mental health board, Your Honor?
Oh, Ms. Ferguson will talk to you about that.
Excellent.
All right, what date? August 15th. And Ms. Ferguson will do a referral to mental health court. All right, after you sign the reset form, you are excused. You're welcome. Bye. Christian Smith. Hello. Okay, where are we on this case?
Judge, I have an offer from the state today. I want to make sure that Kelly has all the discovery that she feels she needs, and Mr. Smith would like to have a little bit of time to evaluate his options.
All right, Ms. Ferguson. On Christopher Smith, can I have a 30-day reset? That will be your discovery date.
We'll do the 17th.
All right, we'll be back on
You do the following week, Judge?
what's happening on the 17th.
I may be out of state that whole week. The 14th through the 21st. I'm lucky.
You're saying the 14th?
Week of the 14th, you're talking about August, right?
Yes.
Yeah. That's the week we hope to be.
So you're out the week of August 14th? All right, Ms. Ferguson, can you call this before then, before August 14th for discovery?
August 10th.
All right.
All right, so we'll be back on August 10th for discovery.
Okay, thank you. Is Mr. Smith excused?
Once he signs the reset form.
Mr. Barron.
We're back. I just need to talk to Ms. Clark.
All right.
All right, so Norma, the people we have remaining are Daniel Perez with Carlos Martinez. I think Will Brooks is taking care of McCaslett. Shawana Canales with Kelly Green.
She's up here.
Yes. Oh, that's, yeah. Manuel Mendoza with Anthony Cantrell. On the next page, Mario Aguilar with Robert Geyer.
He's out here.
All right, that's a plea. Thank you. Kevin Jones with Charles Blanc.
Charles Blanc is in trial.
Did we already reset that?
Not that I know.
All right, could I see the file on that, please? And is Kevin Jones already out?
No, Your Honor.
All right, Ms. Ferguson. Let's recall this in 2 weeks then for Mr. Bach.
July 31st.
All right, could you let him know his attorney's in jury trial and we'll bring him back on the 31st? And if his attorney wants him back sooner, we'll bring him back sooner.
Yeah, almost like it. Okay. And Judge, it's gonna be a plea on the other one. With Kelly.
Shawana Canals.
Okay. And then Norma, we have Clinton Barnes with Sharon Thorne.
She'll be on her way, Judge. She was,
Okay.
in another country.
We have John Kuntz with Aguilar.
He'll be on his way, Judge.
And I believe Zavala is going to be a plea. Patrick Sanchez, this attorney is in a jury trial, but he said he'll come back up if he's able to. And then we have Mr. Cox.
And Mr. Cox is here.
Yes.
They requested Patrick Sanchez.
Okay. All right.
You might want to. You
Oh.
want him in the back, Judge, or?
Oh, Norma Kelly's here. Is she still with Charles Blanc?
Yes. I don't know who he is.
Well, maybe they didn't want their guy sent back. Kelly, are you here for Charles Blanc? His client, Kevin Jones, are you okay with resetting that for the 31st?
I think so. Can I check the schedule real
Sure.
quick just to make sure? And would it be for a trial, Judge?
No, this is his first setting. That's just for discovery.
Okay, yeah, that'll be fine. Looks like Charles is. Looks like he's out,
Okay.
but Lindsay may be here.
Okay.
So is that?
Yeah, that's fine.
Okay.
All right. So it's being recalled for July 31st.
Okay, all right. Thank you, Judge.
Thank
And
you.
Is he in custody or?
He's in custody.
Let's see, is he looking back?
He's downstairs.
He's downstairs. Do you need him?
I'll just set up a visit. That's fine. Okay,
Okay.
thank you, Judge.
Thank you. All right, I'm going to take a short break. 5 minutes.
It's. I usually. Half years. But it's coming. Let's just start. I was just saying.
Seated. All right, who's here on Daniel Pettis?
There's Mr. Martinez, this case.
Okay.
All right.
I gotta go put some money in my meeting. We'll be back. It's going really quick.
Hello.
Hey, how you doing?
All right.
Yeah, the delivery on it. Yeah. And I had my other guy, we trying not to. It takes 5 minutes. So even Judge Watman would take it to notes. What's the big commercial? I think at least I get a commercial. Then come back. You have a decision. Yeah. He's over there. I'll be back. I got it.
No.
But I'm here. I'll try to get back there soon as I can.
If she could, I'll just let him.
Hello, how's it going?
Oh, pretty good. How about yourself, John?
Oh, I cannot complain. It's a beautiful day, but it's not a beautiful day for this pro golfer. The airlines lost his golf clubs. And I shouldn't laugh about this, but he flew on Spirit Airlines and they lost his clubs.
I'm taking Spirit and I'm taking United and won't find it
Yeah.
anymore. Because they've lost my luggage too.
And he posted the replacements that they gave him. And he said, these are hilarious, the replacements that they gave him, because I'm sure his golf clubs cost a lot. Well, hopefully he gets his
Her attorney's in Dallas. And he said he can get a call tomorrow or Thursday.
Okay, that's fine. Oh, so Mr. Martinez, what did you need from me?
I have a big one. I thought the paperwork was-
Oh, yes, it is here. Daniel Pettis, right? All right, Mr. Pettis. Court is calling 2022 CR 1782, State of Texas versus Daniel A. Pettis. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Carlos Martinez for the defendants.
Are you Mr. Pettis?
Correct.
Showing you what's entitled acknowledgment of discovery. Defense, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Pettis, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it?
Right.
And did you sign it?
I did.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are proceeding on the paragraph 2 of the only count on there, striking the language from the paragraph. Allegations paragraph. Column.
Striking I'm sorry, I didn't hear.
Striking the language from the first paragraph, Your Honor.
All right, so you're proceeding on the lesser included offense of a Class A misdemeanor?
That's correct.
All right, any objections?
None, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Right, I did.
All right, did you understand the lesser included offense is an assault, bodily injury, married, or cohabitation? That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to and up to a $4,000 fine. Did you understand?
I understand.
If you have a plea bargain agreement with your there's a lot of noise in the box. All right, could everyone please whisper in the box? Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I understand.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Correct.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
I understand.
And did you intend to give up those rights and enter into a plea in this case?
Correct.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
I understand.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he was.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Correct, I did.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, married, cohabitation. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 663004. There's an affirmative finding of family violence, and there's to be no contact with Daphne, Dafne Torres. Did you understand that to be the plea? Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
I understand.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? All right, did you understand that to be the entirety of the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph, did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I understand.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 1 year and there be the BIPP program. Did you understand that was recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offense, the lesser included offense of assault, bodily injury, married, cohabitation. How do you plead? Guilty, not guilty, or no contest? State any evidence?
State offers State's Exhibit 1 and all its attachments.
Defense has no objection.
All right, you can continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
As the way my client explains it, Judge, is it just situation got out of control. He's learned his lesson. He's telling me that this court or any other court would never see him again. He's got a good job now, a very good job, and he just hopes that the court would consider following the plea agreement.
All right, and I see in the police report, it has County Court 13 as a complainant. Does that have to do with the case that's being taken in consideration?
It's not out of the same incident. He drew up a protective order because of the assault.
Okay.
And
is that why they have County Court 13 in the?
Right.
Okay. All right. How old are you?
I'm 23.
All right. So what do you do?
I work tech support for Verizon.
Do you have any children?
No.
All right. Do you have any property with the complainant in this case?
No.
All right. So were you all living in an apartment together?
We were.
All right. So where are you living now? And when I say living, I really mean, I guess I should say, are you living by yourself now? Or are you living with someone else?
With my
All right. Any drug issues? If you're drug tested today, will it be clean? Tell me. Okay, why are you smiling? I saw a mischievous glint in the eye. So is it any marijuana or anything like that?
just like if anything, it would be marijuana, but I haven't smoked in a long time, but I know it does stay in your system for a little while, so.
Okay, you can't, I know some people, how they are about marijuana, but in Texas, marijuana is still illegal.
Right.
And while you're on probation, you're not allowed, according to the rules of probation, you're not allowed to drink alcohol at all either. You understand?
I understand. That won't be a problem.
All right, counsel, is there going to be a drug issue with your client
As far as I
that you know of?
every time he's been in my office, he's been very lucid and no signs at all.
Okay. All right. I'm going to sentence you to 1 year deferred adjudication, the BIPP program, proof of employment within 15 days. I'll know that you already have employment. There's to be no employment as a home health care provider with minors. There's an affirmative finding of family violence. There's to be no contact with Daphne Torres. You two are broken up.
Right.
So your relationship is over. You understand that in the eyes of this court, your relationship is over. If you decide that you want to have contact with her, you'll need to have your attorney approach the court to have this lifted. Otherwise, if you have contact with her while you're on probation on this court, that's going to be a violation and you could be looking up to a year in jail. You understand?
I understand.
All right, no contact with Daphne Torres, regular UAs. And if you can do regular UAs or either do the patch, whichever is easiest. Patch costs more money, but it's less, it interferes less on your time constraints because they just put a patch on you and tell you when to be there for them to take it off. So probation, he can either do regular UAs or the patch, regular reporting by Zoom or in person. And if you all could just do one field visit, if everything is okay after that one field visits will not be required. 80 hours of community service restitution. You can either do those hours or you can pay $7.25 per hour towards the San Antonio Food Bank. If you don't want to do it for the food bank, you can do it for any other charity of your choosing, but before you pay it, contact probation and they'll let you know if that's an appropriate charity. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Thank you.
All right. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Oh, you'll go around. Yeah. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, You do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
I understand.
All right, good luck to you. We're going to go off the record. If you decide to get into another relationship, get an orchid. That's what I always tell people. Because orchids, when you get them from the store, they have the flowers on them when people give them to you, and then the flowers fall off. So when you get you an orchid and the flowers fall off, do not get involved in another relationship until you can get that orchid to rebloom.
Understood.
And if you do that, you'll realize that you have patience, because it takes a lot of patience with orchids. And some of them, they tell you, put them in the sun. You put them in the sun, they don't like it. Some of them say, you're moving it too much. Some of them say 3 ice cubes, which everybody that I know who's an expert says that 3 ice cube thing is just a bunch of nonsense. So that's why I always tell people to get an orchid. Not that I think this isn't serious, but I say that because orchids really do teach you to have patience. All right, good luck to you. Oh, and the first Space Jam was better than the second one.
It really does.
I'm just gonna tell you. All right. Thank you. Yes. Who's here on Clinton Barnes?
I am not.
All right, yes. Where's Mr. Barnes?
I don't know, Your Honor, and I apologize for being late.
Oh, no problem.
But I had no contact with them, so.
All right, we'll go on the record. Court is calling 2023 CR. Well, let me ask you this before we go on the record. Do you know if he's on bond or is he on a PR bond? All right, if you all want to find that out, if he's on bond, maybe you want to call the bondsman before I have a hearing. Okay. And then after this case, it's going to be Nancy Zavala. And probation, there's no application on this case. All right, court is calling 2023 CR 4712, State of Texas versus Nancy Zavala. Can I have parties announced for the record for the state? Defense? And are you Ms. Zavala? Thank you so much for dressing appropriately for court. I appreciate that. All right, counsel, have you received all the discovery? Did you review it with your client?
I believe so, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Zavala, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you weigh the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe so, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so, Judge.
Ms. Zavala, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 90 days in the Bexar County Jail under 1244. The state will take in consideration NIMAG number 691192 and 709885. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
It is, Your Honor.
showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Say again, Your Honor.
Have there been any such motions?
No, there is.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Okay, Your Honor.
State any evidence to support the plea?
Yes, Your Honor. City exhibit number 1 with office attachments.
No objection.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in the evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing, counsel?
Not at this time, Your Honor. We request from the court that Ms. Zavala be allowed some time to get her affairs in order before she presents herself for custody.
All right, so Ms. Zavala, the person who's listed here is the person you were in the store with. Is that the gentleman that's with you or someone else?
No, Your Honor.
All right, so why are you committing these thefts? What's your problem? What's going on in your life? Is it a drug issue? Is it a?
I just made mistakes. I'm here to accept my responsibility.
No, but see, here's the problem.
Yes, sir.
I know you're here to accept your responsibility, but you're going to get to the point, if you continue on this vein, because these are state jail felonies, you're going to get to the point where you're going to end up with maybe a state jail felony as a habitual, which you'd be looking at hefty prison time. There comes a point in time where these theft cases, even though they're state jail felonies, they can be enhanced in Texas. So I'm trying to figure out, 1, what are your issues? Why do you keep committing these thefts? If it's some kind of behavior that maybe can be changed, fine. If it's a drug issue, fine. If it's a mental health issue, fine. Maybe we can do something with it. But this whole thing where you're coming in, I just want to accept my time and be done with it. At some point, your time is going to be real time. So I'm trying to figure out, and I know all time is real time, but I'm trying to figure out what your problem is.
Well, Your Honor, if I may.
Yes.
She has had her issues in the past. I have spoken to her at length.
What are these issues?
That she didn't want. She has impulse control problems. And the part of her problem is going into a store and wanting food or what have you, and not having the wherewithal to go out and earn the money and get the food and consume that item. She has had impulse control problems, but I've talked to her at length, and I believe that she understands the gravity of the situation. And in addition, as the court has informed her, that she may end up facing significant time behind bars if she continues down this vein. She has told me that she has realized the error of her ways and that she has actually, in her mind, reformed.
All right. So has she reformed in the past? And then, because I think, I could be wrong, and if I'm wrong, you can correct me. Sometimes people realize their issues the third, the fourth, the fifth, the sixth time. I understand that. But you have prior convictions for this. State, did the defense confer with you about having this called back for sentencing?
They asked, I said I defer to the court whether be allowed back. I did mention to the defense counsel that we would be asking that the full range of punishment would be on the table if the defendant did not show for sentencing.
All right.
Yeah, that was informed, and I was aware of that, that if the court does grant this, that the court has in the past.
All right, Mrs. Zavala, is there a reason why you can't go into custody today?
Well, get my stuff like arranged, like with my boyfriend, the rent. Like let them know that I'm not gonna be paying the rent no more, like at the moment. And then with my kids, well, my son, I just had a grandbaby. And I just wanna meet her, I haven't met her. And I wanna meet her. Yeah, and that's just the truth about it.
So how old is this grandchild?
She was born February 13th,
Why haven't you met her?
because they were out of town. They were out of town, so they barely came back. What was it, last week? Was it last week?
Yeah.
So your grandchild has been out of town for 5 months?
Yes, yeah. But they've been busy. They've been going back and forth to Mexico to Piedras Negras. And so they've been with his wife, my son's wife. He's from over there, so they've been going back and forth, back and forth. And so he said that I can meet her this Sunday coming up at church, at the First United Pentecostal Church on Utopia Street.
All right, we're coming back on July 17th.
Oh, yes, Your Honor.
Ms. Ferguson, can you give them a reset form for July 17th?
Thank you, Your Honor.
And you understand a part of your plea bargain agreement, if you do not present yourself on July 17th, then you're subject to the full range of punishment. Do you understand?
Yes, Your Honor.
And that full range of punishment is up to 2 years in the state jail facility. Do you understand?
Yes, Your Honor.
All right, we'll see you back on the 17th. You're welcome. Ms. Ferguson will give you the reset form, then you're excused.
Thank you.
All right, are we ready on Mr. Yost?
State's ready, Your Honor.
Mr. Cox, are you ready?
Yeah, we're ready. Yeah.
Okay.
Right.
All right, and the court usually does not do this, but because there were notebooks that were presented to the court did review those. So we're going to go on the record. Court is going to call 2020 CR 9647, State of Texas versus Jonathan Keith Yost. Could I have parties announced for the record for the state?
Richard Getta for the state.
Defense?
Cornelius Cox.
Are you Mr. Yost? All right. So in this case, the court was presented with a lot of exhibits, and those exhibits include these 2 notebooks. The court did review those once the court was made aware from both parties that this was going to be a plea that was going to be entered. Any objections to the court having reviewed the 2 notebooks, one being black, one being white? State?
None from the state.
Defense?
Oh, yeah.
Mr. Yost? Okay. All right, counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Yost, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
So you're proceeding on counts 1, 2, and 2?
Yes, Your Honor.
Okay, thank you. All right, Mr. Yost, I'm going to show you what's entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in each count You're charged with the offense of theft over $300,000. Well, theft over $300,000 and money laundering over $300,000. Did you understand?
Yes.
All right. Each of those counts are first-degree felonies. The range of punishment is 5 to 99 years or life in prison with a possible fine up to $10,000. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Yost, has anyone threatened you, coerced you, or placed you in fear to get you to end this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 20 years in the prison. The state makes no recommendation for a fine. There are no applications. There's to be restitution to Dr. Ashok, A-S-H-O-K, Thopady, T-H-O-L-P-A-D-Y, in the amount of $400,000, and there's to be no contact. Did you understand that to be the plea?
Yes.
Defense?
Sure.
State?
Yes, Your Honor.
I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Clear.
Then to count one in the indictment, how do you plead? Guilty, not guilty, or no contest? Count two, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 in all attachments.
No objection.
All right, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty in count 1 and guilty in count 2. This will come back for PSI on August 24th. Mr. Yost, at that time, the court will make a decision on your sentencing based upon the PSI report I received back and any other evidence that's presented to me. Do you understand? Oh, it's a pre-sentence investigation report. Basically what it is, it will show me what your criminal history is. It may have statements in it from the complainant, statements maybe from yourself, and any other information about you. And then I'll base my decision upon that and also any other evidence that's presented to me. Do you understand?
Yes.
All right. And Mr. Yost, just so you know, I will receive the PSI report, but I don't review the PSI report before both the state and defense have had a chance to review it and let me know if they have any objections to it. So I'll review it after that point. All right.
If I may.
Yes.
With the, with my client's bond status.
Mhm.
His bond was set very high. And the problem is that it's not that he was trying to buy out. The issue is that because of the high bond,
Mhm.
he's locked down
Mhm.
23 hours.
Okay.
And we're asking the court if
the court, even if the court remanded him without, then I think he will go back to general population. We just want him in general population, so he's not locked down 23 hours.
Well, why don't you, that can be accomplished by one or two ways. One, if you want the court to remand him without bond, I'll remand him without bond. If both of you all would like for me to contact the sheriff's department and say, you know, what is the reason for his lockdown? Is his lockdown because of the high bond or something else? Then the court can look into that.
Okay, that'll be fine. If we can get him to in regular population, that's always
Okay.
GP.
All right. So if both parties are okay with the court asking the sheriff's department why he's in lockdown?
I'm okay with that, Your Honor.
Okay.
It's a bond.
Okay. All right. So I'll talk to them today. I'll put that on my to-do list.
Thank you.
Okay.
Thank you, Your Honor.
You're welcome. Yes. It's August 24th. Who's here on Shawana Canales? Court is calling 2023 CR 2080A, State of Texas versus Shawana Canales. Oh, we do have the interpreter. All right, if you all give me a moment, let me take up the matter with the interpreter very quickly, and then I'll call you right back up. All right. No, no problem. All right, who's here on Edgar Aguilar? All right, thank you. I'm sorry, I did not see you all. All right. And counsel, in this case, is there an immigration attorney needed as well?
So he has a private immigration attorney. He's a resident.
Okay.
He renews his residency annually through his private immigration attorney. So I would like, and two offers have been conferred, have been conveyed today. And I would like the opportunity to talk to his private immigration attorney to see what consequences, if any, he would incur through either offer.
Okay. All right, so do you have all the discovery?
Yes. Discovery.
All right, Ms. Ferguson. On this case, put the plea deadline date for 45 days. And that'll give you a chance to speak with the immigration attorney. And if you want it brought back sooner, just let Ms. Ferguson know. We'll put it on the docket sooner.
Perfect. Thank you.
You're welcome. All right, we'll come back on August 24th. All right, thank you. All right, now if I can see Shawana Canales. All right, the court is calling 2023 CR 2080A, State of Texas versus Shawana Canales. Can I have parties announced for the record for the state? For the state, sorry. Nope.
Jason Garahan.
For the defense?
Robert Barron's on behalf of Kelly.
All right. And are you Shawana Canales?
Yes.
Do you have any objections to Mr. Barron standing in for Ms. Green?
No.
All right, state any objections?
No.
Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Canales, I'm showing you what's entitled application for deferred adjudication, community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Did you sign it?
Yes.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes, we are.
Showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Did you understand you're charged with the offense of theft 2,500 to 30,000? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Been able to assist in her defense. I believe she understands the proceedings against her and that she's confident that.
All right, do you believe she was sane at the time of the offense?
I do.
Ms. Canales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea, there is a $500 fine. State recommends deferred adjudication. They will take in consideration night bag number 711174. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both
Yes,
places?
sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Next, I'm showing you outside the agreement. The state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 140 hours of community service restitution, and no contact with Clifton Smith. Did you understand that those are recommendations from the state and the
Yes, sir.
court does not have to follow those?
Yes, sir.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No, ma'am.
State any evidence?
State executive number 1 with all its attachments, Your Honor. There's no objection, Your Honor.
Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
That's that the court followed the plea bargain.
All right, Ms. Canales, what is your relationship to Alejo Aguirre?
None, ma'am.
So why were you with him?
I know him from down the street where I was living at, and he had asked me if he could place a set of tires at the residence. So I agreed. I went with him to go pick up, and what ended up him picking up tires ended up him picking up a stack of some pellets, like those wood pellets, and that was the reason of the arrest, because he didn't have permission to pick those pellets up.
All right, are you employed?
No, ma'am, not at the time.
When's the last time you were employed before being taken into custody?
In 2011.
All right, why have you not worked since 2011?
Mental issues,
All right, what are your mental issues?
schizophrenic and bipolar.
And have you received a professional diagnosis of that?
Yes, I was on medication before in the past. I just stopped taking my medication for a while.
Are you on medication at the jail
Yes.
for the schizophrenia and bipolar?
Stabilized.
Do you have any children? What are their ages?
24, at 23. And then I have a 15-year-old.
All right, where's the 15-year-old?
My 15-year-old's outside
Okay. And I'm assuming school's not in session.
And then, I'm
They're
sorry,
enjoying summer.
and then my son is at the.
Background judge.
Okay. So if you're released, do you have a place to stay?
Yes, ma'am.
And who would you be staying with?
A friend of mine,
Who is this friend?
Enrique Rangel.
How long have you known this
I've
person?
known him for all my life, like, since my daughter was born. He's her uncle.
Okay. All right, this is what the court is. I'm sorry, is there any questions from anyone else?
So judge.
All right, this is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication, 140 hours of community service restitution. I'm going to ask for parenting classes. Once she completes the parenting classes, the community service hours will be deemed to be satisfied.
I don't have custody of the children. But I mean, I'll still do that.
Well, I mean, your 15-year-old is here for some reason,
Oh, I'm sorry.
right?
No, yes, I'm sorry. No, I'll do the class.
Okay.
I'm
Nope.
sorry.
Oh, no, there's no problem. I'd like for people to speak so I can figure out what's going on. There's to be no contact with Clifton Smith or Alejo, Alejo Aguirre. Taking consideration NIMAG number 711174. I'm going to want a referral to Center for Healthcare Services, regular reporting by Zoom or in person, regular UAs, and I'm going to want field visits 1 time per month until further notice. And probation, once she is with Center for Healthcare Services and they've given her a case manager, then the court will consider lifting the field visits 1 time per month. All right, probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court?
The TAP evaluation, am I able to take the TAP evaluation out on the free world or?
Yeah.
Okay.
So why do you think you need the TAP evaluation?
Well, it was in.
Recommended by the state.
Okay, all right, and I'm sorry, we're gonna do proof of employment with proof of employment or SSI within 45 days. And there's to be no employment as a home health care provider or with minors. And I'll allow her to do the TAP evaluation out of custody. You need to make sure you make your TAP evaluation appointment. If you don't make that appointment, then what's going to end up happening is I'm going to receive notice that you haven't made that appointment and a motion to revoke is going to be filed. You understand?
Yes, sir. Yes, sir.
All right. And we'll follow whatever the TAP recommendations are. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in both places? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you. Thank you.
You're welcome. Mario Aguilar.
Let's see the second chair.
Court is calling 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Robert Gear, Your Honor, for defendant Mario Aguilar, and we're ready.
All right, and are you Mario Aguilar?
Yes, Your Honor.
Counsel, you received all the discovery. Did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense? Mr. Aguilar, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
President.
Counsel, have you had an immigration attorney speak to him?
I have not had an immigration attorney speak with him, Judge, but prior to this situation, he was already being addressed with immigration. Prior to this, he has a court date in immigration court. And from what we know, this is not going to affect what is going on in that.
All right, let's do this, because I would feel more comfortable if he had a chance to speak to an immigration attorney concerning these charges. So, Ms. Ferguson, can you see if you can have somebody from MAC come down with regards to immigration? We'll take care of this, Mr. Aguilar, but I want to make sure that you know all of your rights. So sometimes things that you do on the criminal side, well, not sometimes, always has an effect or impact on your immigration status, all right? So, Ms. Ferguson, let's see if we can call MAC down, and then once they speak with him, we'll see how long they need for me to make a decision on this, okay?
Yes, yes.
All right, thank you. Chris Lind. All right, and the court has signed the protective order. So, Mr. Cox, you're on this side. So we have the CPS records, is that correct?
Yes, Your Honor, I just uploaded them. I offered if Cornelius has a hard drive, I'll put them on that, but they are on eDiscovery. It's over 6,000 pages, plus probably about 20 audio interviews.
Mr. Cox, it seems like you're becoming a speed reader. All right, so is that the only discovery that's outstanding? That was the CPS record?
My knowledge.
All right, so Ms. Ferguson, on this case, recall this for 30 days and state at that time you need to tender an offer.
Okay.
All right.
30 days?
Yes, 30 days. And it's for the state to make an offer. August 15th. All right. Denise, I think the only way I could get you in to talk about the LSU Florida game is by having you in court. And you know what? When LSU lost, I think it was like 24-4, you were calling me like on a daily. And then, you know what? That's sort of like that commercial, the thrill of victory, the agony of defeat, but at least you had a victory. Yes. Okay. Clifton Barnes. All right. Did you get a chance to call the bondsman?
I did, Your Honor, second chance bail bondsman. I called them. They say that he is aware of the hearing because he comes in there and uses an app every day. So they were going to try to call him, but I haven't heard from him since then. Your Honor, I'm going to be here in your court on Thursday. I was wondering if we call this case to Thursday and give him a chance and give them a chance to get him here.
All right. State, are you going to have any objections to recalling this for Thursday?
No objection.
All right, Ms. Ferguson, on Clifton Barnes, he's going to come back on Thursday and he needs to be here exactly at 9 a.m.
I will call the bondsman right now, Judge.
All right, thank
And
you.
excused.
Yes.
Thank you.
I was just gonna
say Sarah. I'm trying to get Sarah May down here.
Who? Okay, thank you. All right, and we're getting ready to take a break. Okay. Who's here on Sean McCaslett? All right, so Mr. Brooks, we're gonna take our. Okay, all right, McCasley, come on up. And then after this one, we're taking our break. Court is calling 2023 CR 5724W and 2023 CR 5797W State of Texas versus Sean Kevin McCaslett. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor. Will Brooks for the defendant, Sean McCaslett.
And are you Mr. McCaslett? Counsel, have you received all the discovery in each of these cause numbers and did you review it with your client?
Yes, Your Honor.
In each of the cause numbers, the court will find that the state is in compliance with discovery. And each of the cause numbers, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it? And each of the cause numbers, I'm showing you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that, those documents with your attorney? Did you understand it and did you sign them? Did you understand by signing that you're waiving your right to have a grand jury hear the evidence in this case? You're also waiving the right of your attorney, certain rights that your attorney has, namely your attorney has 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand by entering these plea bargain agreements in each of these cause numbers, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, I'm showing you what's entitled information. Did you review those with your attorney? Did you understand them?
Yes, sir.
Counsel, do you waive the reading of the information in each cause number?
We do, Judge.
State, are you proceeding on the information as presented?
Yes, Your Honor.
All right, in each cause number, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in each cause number, you're charged with the offense of theft of aluminum, bronze, copper, less than $20,000 as a habitual offender? So the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering these pleas, you were giving up those rights? Did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's my belief, Judge.
Mr. McCaslett, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas? Has anyone promised you anything other than the pleas? Are you satisfied with the way you've been represented? Are you a U.S. citizen? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it? In each of the cause numbers, according to the plea, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. State recommends community supervision. The cases will run concurrently. The state will take in consideration 2022 CR 7824. NIMAC number 795249, 795252, and there's to be the anti-theft course plus restitution, if any. Did you understand that to be the plea?
Yes,
Defense?
yes, Judge.
State?
Yes, Your Honor.
And each of the cause numbers, I'm showing you the waiver of repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
Motion's been overruled. I'm sorry, motion's been overruled.
Okay. Outside the agreement in each case, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, random UAs, and sober support meetings to be determined by probation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I can't hear you.
Yes, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest? State in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor, I submit State's Exhibit 1 in the attachments, Judge.
We've reviewed both in both cases, Judge, and we have no objections.
In each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. All right, we're going to go off the record for a moment. All right, Mr. Haslett. And each cause number to the enhancements, how do you plead, true or not true? And each of the cause numbers after reviewing states exhibits 1 and attachments, the court will find you guilty and the court will find the enhancements true based upon your plea of true and also based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Judge will waive it. Yes, I am.
All right, anything you wish to say on behalf of your client?
Your Honor, in respect to Mr. Haslett, you struggled with drugs. I've got a pretty extensive background on him from my investigator. Fortunately, he came up in a very tough home. His mother was an addict. Mental health issues. I'm sorry.
Okay, we can't hear.
She passed 3 years today.
Okay.
And he struggled with the dick, Judge. These are the result of the same, but in this instance, Judge, he's been in custody for 4 months. He's made a decision that he wants to change.
All right. Do you have any children, Mr. Haslett?
Yes, ma'am, I do.
And what are their ages?
A 17-year-old man, 13 and 3 girls.
And do they stay with you or no?
No, ma'am.
So who do they stay with?
Their mother.
Has Child Protective Services ever been in your life? And when's the last time you had employment before being arrested?
I want to say in January.
Okay. And have you had any type of treatment before?
Yes, ma'am, Your Honor, I also have a sponsor out there.
A sponsor?
Yes, ma'am.
Have you ever had any inpatient treatment? What type of inpatient treatment?
Exciting.
All right. All right, and each cause number, this is what the court will do. Court will sentence you to 10 years in prison, suspended and probated for 10 years. There's $1,000 fine. That will be probated. This will run concurrent. Each case will run concurrently. Take in consideration NIGHTMAG number 795-249, 795-252, 2022 CR 7824. Counsel, since you're in felony drug court, is his history such that felony drug court, he would pass the screening?
It may be, Judge.
Okay.
I don't know what the status is as far as numbers go, but we talked about it before. I think she's willing to get some help, certainly, Judge.
All right, we're going to do a felony drug court and TAP evaluation in custody. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. CATs 1 and 2. Regular reporting by Zoom or in person. The UA hotline. Field visits. 1 time per month. Until further notice. 100 hours of community service restitution. And once you complete parenting classes, those will be deemed to be satisfied. Is there anything else with regards to sentencing from either side?
I think the state's got to
Dismiss.
dismiss, and then also the TIC, Judge. Yes, and misdemeanors, and I'll make sure we get those set up.
All right, probation, is there anything else he needs? And each of the cause, is there anything else you need from the court? All right, and each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, Mr. Hazlitt, good luck to you. We can go off the record. And this court, communication is key. So if there's an issue, let probation know. If you feel as though probation is not addressing it, then just let the court know. Okay? All right, good luck to you. You're gonna have to do better, okay?
Thank you, Judge.
You're welcome.
Sorry about the paperwork.
Oh, no problem. It happens. All right, I guess we'll be back tomorrow, Norma.